My name's Polli. I am a partner and head of the family team at Pinney Talfourd Solicitors. I'm here today with my partner, Claire Spurgeon. Claire, tell me about your role within the family team.
I'm Deputy Head of Team and I'm based in the Brentwood office.
You deal with a lot of our complex financial remedy work because of your years of experience. Tell me, what options are open to clients when they decide that they want to separate and they need to sort their finances out? What can they do?
There's several options. The first option is that they can talk amongst themselves and reach a settlement between them and then come to us to try and implement that for them. Alternatively, we can have solicitor-led negotiation where we go through some disclosure and then we give them some advice about what to do. If that doesn't work, or in the alternative, mediation or other forms of ADR such as arbitration, and then unfortunately if all else fails then it may be an application to the court.
What do you think is the most successful way of resolving those financial problems? What do you see work in practice most?
I think it's a combination of things, but I would say that mediation is a good start, and often the issues can be narrowed between the parties. Sometimes it needs to come back to us so that we can fine-tune that and give clients advice about what may or may not work in that settlement. But if mediation doesn't work, then try solicitor-led negotiations because costs of court proceedings can be very expensive. Ultimately, if we end up at court, then it's trying to resolve it early on in the proceedings to save costs.
So Claire, you and I both know that sometimes mediation, the best-led solicitor negotiations, they just don't work. What do we then do if we cannot get matters agreed?
If we can't agree matters, then we're going to have to make an application to the court. It's a prerequisite that you attempt mediation, so you have to go to mediation, even if the other party won't engage in it, just so the mediator can sign it off that you've attempted to mediate. Then you make an application to the court using something called a Form A. You can do it online, and the court will then issue your application and set down a series of hearings. The first thing you're going to need to do is complete a Form E financial statement, which is a summary of your financial circumstances and also your expectations for the future. They're the same documents that we use actually when we're trying to keep things away from the court and to have solicitor-led negotiations. So they're a useful tool either way.
How critical is it that a solicitor supports you through the drafting of that Form E?
Exceptionally important, because often those initially drafted documents are referred to much later in the proceedings, particularly if you maybe attempt to change your position, or sometimes where you've done a voluntary Form E before you then issue proceedings and then you've done a secondary one within issue proceedings, the two can be compared. Also, when you're looking at future needs such as outgoings, what you need to live on, in the first Form E you're often setting out what you need. Later on that's going to be reviewed when you look at what you might need to live on in the future, and if you're trying to modify those expenses, what you've said initially is going to be very important. So it's often overlooked the importance of that schedule of outgoings. So the form in the first place, once you're within issue proceedings, it needs to be completed as accurately as possible.
Thank you. We then move on to the actual court proceedings themselves. Can you talk us through how those court proceedings work in terms of hearings and timetabling?
Sure. So when you issue proceedings, you'll usually make an application via the online portal. The portal will then issue your application and give you a first appointment, which is the first hearing you have, when the judge will look at your Form E. So the court will originally give you a date for your Form E and when it needs to be prepared and when it needs to be exchanged with the other side if they've got representatives, or with your spouse if he or she is representing themselves. And then approximately 4 weeks after the Form E's have been exchanged, there's an FDA hearing, a first directions appointment, and that's the first hearing at which a judge will look at what you've both said respectively about your financial circumstances, and will look at where things aren't agreed, such as property values, if there's businesses to be valued, if there's any other issues which the court needs to have determined before it can assist in making a decision as to how things should be divided. After that FDA hearing, any directions the court has made, that need to be complied with are carried out, and then you have a secondary hearing called an FDR hearing, a financial dispute resolution hearing, at which the judge will then look at all of the evidence that's been filed by the parties, all of the financial information, and will then try and assist the parties in reaching a settlement by giving an indication that if this was, say, a final hearing, what he or she might order as a final order, and that will then give the parties cause to reflect on what their respective positions are and whether or not somebody needs to modify their position in order to try and get it settled. And then if they don't settle it, unfortunately it's set down for a final hearing, and that's when a judge will, a new judge that hasn't looked at the paperwork before, will make a determination as to how the assets are divided.
You mentioned cases which are complex effectively, where we need external help. Who else gets involved? Because we use other professionals, don't we? We use professionals for court and we use professionals to support our evidence. Can you give me some flavour of the types of other professions that we work with?
Yes, largely pension actuaries, where parties have pensions, usually not ones that are worth 20, 30,000, but if you get to pensions that are worth cumulatively over £100,000 or more, then often the court will be looking at asking for expert evidence as to how those pensions should be divided, sometimes in order to create equality of value, sometimes to comment on how the pension should be divided so as to provide equality of income in retirement. And the bigger the pension, the more complicated those calculations are. So we can't advise on that. The actuary has to give expert evidence as to how the pensions can be more fairly distributed in order to achieve equality. Alternatively, sometimes business valuations, so accountants. So if somebody has a business that needs to be valued and one party wants to keep it, often within married couples, both parties may be shareholders, maybe directors. We want to find out how we can transfer the business from one party to the other without the exiting partner being prejudiced. Often there are other tax considerations, capital gains tax, if we are selling investment properties, if we are selling shares in a business. So often accountants and actuaries play quite a large supporting role in providing the expert evidence that's required for the judge to then make a decision, or for us outside of court proceedings to assist in reaching a settlement.
Yeah. We do some of our own advocacy here at Pinney Talfourd, but we also use counsel. I know you use counsel for your big financial dispute resolution hearings. How do you choose your counsel? What do you look for?
I think it's a mixture of things. I suppose reputation. We, as a team here, talk a lot about who we instruct and who we like. We have a list of approved barristers. We will feed back to each other about who's provided exceptional preparation for a hearing, who's provided exceptional advocacy, who has spotted more intricate arguments. I tend to use, I think we all get our favourite barristers, so I do tend to use 4 or 5 people regularly because I know that they're thorough, and I think that they enhance or provide a second level to the advice that I'm giving, and I think they're similar in style to me. And I think when you build a rapport with your client, and then if you're sending your client into court with counsel, they need to be an extension of you rather than a completely different personality with a completely different approach. But ultimately, reputation and talking amongst our peers as to who we think is good.
Yeah. Disclosure, always an issue in family cases, and we get asked by our clients a lot about what they need to disclose. What are the rules about disclosure? What are they supposed to disclose to the court within financial remedy proceedings?
The duty of disclosure is full and frank, and it starts from the very beginning of your matter and it goes on right through to the very end. If you have any change in your circumstances during the continuation of your case, you have to disclose it, and you have to disclose it immediately. That means if you come into an inheritance, if you win the lottery, if you have some sort of windfall that you weren't expecting, you still have to disclose it. If you don't disclose it, then the court has the ability to set aside any order you did reach, because the other party would be able to say, but had I known that in the first place, I would never have reached the agreement or never come to the agreement that we have. And the court can then set it aside and look at the case again. Particular examples of that are people, say, who are due to get share incentives from work and things. They're often the things that are sometimes delayed, that people maybe know about before a final hearing or a settlement. They're vested afterwards, but because they knew about them and they didn't disclose them, that can give the other party the ability to set aside any order. So you're better off disclosing it, because if it's found out about afterwards, you're not going to get away with it.
Okay. What about things like where the assets are your asset but potentially aren't in your name? The house is owned by other family members. You have the benefit of a trust. What are they supposed to do with those?
But if you know you have a beneficial interest in a property, but the property is not held in your name, so say for example, you own a property with your sister beneficially, so your sister is on the legal title, but actually you both contributed towards it 50-50, and you know that if it was sold you're going to get money back, then you have to disclose it. It's not just about assets that are in your name, it's also the disclosure process has to include anything that you also have an interest in, even though your name might not technically be on the title or the bank account or whatever it may be.
What about assets abroad?
Same applies. It's not disclosure isn't just about what you own here in the UK, it's also about what you own abroad, so holiday homes, if you've lived abroad and come back and you've retained investments elsewhere, if you have parents that live abroad that have maybe left you a bequest and that's still vested abroad, you still have to disclose everything, because ultimately the court need to look at the entire pot that's to be divided, and that includes everything you have, no matter from what source, as a starting point. There may be arguments then about ring fencing them and taking them out of the equation because of when they were obtained by you. Were they gifted to you before the marriage, for example? Have they been subsumed within the marriage? Have they been wrapped around other matrimonial assets, or have they been kept completely separate? There are arguments that you can raise with the court or within your negotiations to try and ring fence some of those assets, but the starting point is it all goes in, and then you talk about what might be able to be left out.
Lots of people assume that it's 50-50, but it's fair to say from what you say that lots of these cases are very complicated. What do you think? Yeah,
the starting point is an equal division. For every case we start from an equal division, but then we have to look away from the 50-50 division depending on need, for example. I think there's a misconception often amongst the public sometimes that you get married and that's it. Whatever you had at the point you got married is then being shared equally with your spouse, whether the marriage lasts 2 years or 30 years. That's not the case. The shorter the marriage, the less likely it is that you're going to have an equal distribution depending on who brought what to the marriage in the first place. Longer marriages, the starting point is more likely to be an equal division and end up as an equal division. But often in those cases, whilst that might seem simple, it's about ascertaining what exactly that 50% is, because there will be disputes over valuations of certain assets. And so even the most simple cases often can end up being a little bit more